Chairman, thank you. The Attorney General has submitted written testimony on this bill, and I know you've been here a lot tonight because of one of our bills, so I'll be as brief as I possibly can. The life without parole statute and the murder statute, when it comes to juveniles, you have to be waived into the superior court system and the adult system to reach that level. When you're a 16-year-old or younger, you have a discretionary waiver hearing where the court considers probable cause and whether you can be rehabilitated in the family court system. If you are a 17-year-old and you can commit murder, sexual assault, child molestation, or assault with intent to commit murder or sexual assault, you can be mandatorily waived into the superior court. At that time, you have a full trial as an adult, and if convicted by a jury or peers, you could either be sentenced to life without parole or life. Life without parole, you can only reach under 8 enumerated sentences. Only under 40 individuals in our state are currently serving life without parole, and I can assure this committee that none of them are juveniles. In fact, only 8 individuals that we know of are serving life as a juvenile once they've been appropriately waived into the superior court. Most of those 8 involved murder, and the other one involved a vicious child molestation of a very young child. I put that on the record before you is because to make a point. These statutes, the mandatory waiver and the discretionary waiver, were put on the books when the Craig Price incident happened. It was about a foreseeable defendant and the court system not having a way to deal with him or to waive him out of the family court's jurisdiction. We think that repealing acts such like this would just be waiting for the next horrific crime to happen. We know the juvenile law is evolving. We are watching it every day. But when you talk about a murder, when you talk about a sexual assault, when you talk about a vicious child molestation, and you don't at least give the court an option, that's not in the best interest of public safety. So we are concerned with the bill. We have laid out the instances that we have spoken about in our testimony, and I'm available for any questions.
Thank you, Ms. Lynn Beck. Representative Corvese.
Joey, you mentioned Craig Price.
Yes.
So if this bill was, if this was law while the Craig Price incident was occurring, then he would have been able to be eligible for parole.
That's a difficult scenario to talk about because when the Craig Price situation happened, there was no waiver proceedings, so that all stayed in the family court. So under that scenario, then this bill wouldn't apply to him at all. But if the same charges were committed then and he was waived out of the family court, then this may or may not apply to him depending on the charges. So that's kind of a hard peg to put in the hole.
Thank you.
You're welcome.
Representative Knight.
Joey, I missed the first part of your testimony. Are you guys not supportive, somewhere in the middle with changes?
We don't support the bill.
Don't support, okay. So just for the benefit of the committee, can you tell the committee what happens if somebody becomes, quote, eligible for parole, what they have to do to actually see the light of day outside the prison walls?
They go to a parole hearing, face the parole board and the victims if they show up and appear, and any other public members that want to testify at the parole hearing.
Right, so it's not just becoming eligible doesn't mean, boom, you're out.
Except in life without parole cases, yes. Except for in life without parole cases,
right,
yes.
You're not going to be eligible, you're not going to go to parole.
Correct.
I guess my point is that when you become eligible, there's still a process to go through. It's not administrative such that, boom, you're eligible, snap, you're out. You have to go before the parole board, and in fact, the parole board oftentimes rejects people on their first application for parole.
Yes, and I think that the Attorney General's position is there should be some offenses that are distinguished from that. So if it is the murder of an individual, if it is the rape of an individual, if it's the molestation of an individual, maybe that person should have to wait a longer time because of the severity of the offense and the lifelong impact it has on the victim or their families.
And we have that in our current law, right? I mean, first-degree murder, if you catch life, well, there's life without parole, so there's no parole.
This bill applies to life without parole as well.
Right. But if you, as an adult, if you're sentenced first-degree murder and you catch life, you're eligible at 25 years?
Now, yes,
And second-degree murder is 1/3 the time, right? So if you catch 40,
that's term of years is one.
right, so if you catch, let's say you catch 30, or even the guy in the last 2 bills ago, right, who caught 20 on a plea, he's eligible after 1/3, right? Right. So, I mean, our law is full of these distinctions about when people become eligible, and I think there's a real conversation. I absolutely agree with you that there's a huge conversation to be had about truth in sentencing. And so if somebody catches 20, then, you know, the victims and the people who are impacted by that person's crime should really understand what they're really going to do. But you know, this is the same conversation we've had before about juveniles are different no matter how heinous the crime.